I'm Ayin, and now I will be talking about what exactly is customary international law and its importance. It is within human nature to do the things in life, such as the need for men to go hunt, for us to evolve languages and seek knowledge for our own needs. Although this is not written within any rule, we humans naturally do this to survive as a general practice that every human does because we all have a belief that we are obligated to do so to survive and succeed. And this concept is what we will be discussing on customary international law. Customary international law is typically defined as a general and consistent practice of states followed by them from a sense of belief in their legal obligations. Article 38, Clause 1, Clause B of the Statute of the International Court of Justice defines customary international law as a general practice accepted by the law. In the North Sea Continental Shelf case, the ICJ had emphasized that the courts would apply only a uniform practice that is accepted as law, and it was highlighted that the material of customary international law is to be looked for in the general practice of the states and what states have accepted as law, known as opinio juris. State practices can be seen in the actions of the state in the form of acts and omissions or statements made by them. The state practices must be consistent and uniform and generally accepted by the states. However, in the case of Nicaragua and United States, several clarifications were made regarding the inconsistent state practice. For a customary rule to come into force, it is not necessary to have complete consistency in state practice in respect of the rule. In this case, Nicaragua had claimed that the United States had implicitly breached international law by using the help of direct armed forces against it. The use of force is outlawed by Article 2, Clause 4 of the UN Charter. Nonetheless, the United States had made a reservation to its acceptance to jurisdiction of ICJ, which excludes disputes that are arising under a multilateral treaty from it. However, the court had ruled prohibition of use of force, which was also a rule of customary international law. Thus, it can always exercise jurisdiction in application of such rules. In its reasoning, the court affirmed that for customary rule establishments, its conduct is not needed to have been completely consistent. It is sufficient that if state practices is in general consistent with all the necessary rule, and situations of conduct inconsistent with it are treated as breaches of that rule and not as an indicative of new rule existence. Even if states act in a manner which will be considered incompatible with customary rule, but if it tries to justify its conduct by resorting to various exceptions and justifications contained within the rule, then in those circumstances, this behavior confirms the rule. This is also supported by the Anglo-Norwegian fisheries case. It was emphasized by the ICJ that some degree of uniformity among state practice was essential, but little uncertainties will not amount to serious inconsistency. In this case, the UK rejected drawing straight baselines longer than 10 nautical miles, which were used by Norway for enclosing a number of bays. The court asserted that states did not behave in a manner to demonstrate that the alleged rule formed a customary rule. In the view of the court, if the practice of states is to acquire the status of customary law, such state practice must be common, consistent, and concordant. The second element is that nations must engage in the practice out of a sense of legal obligation. This is referred to as opinio juris, which is the central concept of customary international law, because opinio juris refers to the reason as to why a nation acts in accordance with a behavioral regularity. It is what distinguishes a national act done voluntarily or out of committee, which is based upon a consistent practice in interstate relations but without the feeling of legal obligation. Courts and scholars stated that a long-standing practice among nations would become a rule of customary international law when it is accepted by nations as legally binding. In the North Sea Continental Shelf case, the ICJ emphasized that there must be a belief that this practice is rendered obligatory by the existence of a rule of law requiring it. The need of such belief, the existence of a subjective element, is implicit in the very notion of the opinio juris. The necessity of opinio juris was first pointed out in the Lotus case. In this case, the court concurred with France's assertion that customary international law included a rule that removed any jurisdiction by Turkey over the French ship Lotus, on the grounds that there was no supporting evidence available to the court, which demonstrated the belief of such jurisdiction by other states, as France contended, to the effect that a mere connection did not itself create jurisdiction. France referred to a number of cases which the states concerned avoided instituting proceedings against nationals of other countries in the case of collision on the high seas. However, France could not convince the Permanent Court of International Justice that these states refrained from exercising their jurisdiction due to a legal duty to do so. Hence, despite France's claim that there was an obligatory rule preventing Turkey from bringing such a prosecution, the latter successfully argued that even if most states in Turkey's position had not exercised their jurisdiction, there was no reason to believe that this was the result of a legal obligation. As regards to duration, there are certain indications in national legal systems indicating the requirement of passage of time for a particular behavior or usage. The factor of repetition is usually associated with the duration. In fact, these two factors are interrelated. When it is said that duration is a factor contributing to the establishment of a practice, it is because in a period of time, a certain action of states is repeatedly performed. A long duration helps to establish that compliance with the practice was consistent and also helps to clarify the context and the meaning of the practice. However, duration is not an important factor in generating an international custom. In the North Sea continental shelf case, the ICJ indicated that the passage of only a short period of time is not necessarily a bar to the formation of a new rule of customary international law. Hence, the factors of duration and repetition are not fundamental in the formation process of a state practice. These factors would be supplementary but not determinant. However, the state practice does need to be constant and uniform. Customs are likely to form when all states benefit from a customary rule with low distributional costs, when powerful nations impose a custom on weaker states, and when states seek to entrench shared normative values. The participation in the formation of custom is in principle open to all nations, even if powerful or specially affected countries often have more control over its development than the weaker or less interested states. States are bound exclusively by their own sovereign will. Consequently, all of international law, including customary international law, depends formally and factually on the consent of states. A customary rule binds only those that have accepted it. While some rules have been accepted by all states and represent general international law, many customary rules have been accepted by only a limited number of states. Customary international law depends upon the consent of nation-states, which can be either explicit or implicit. Thus, if a nation does not wish to be bound by a new rule of customary international law, then it can vocally object and announce that it does not view itself as bound. This is where the persistent objector doctrine applies. While acceptance by states of customary norm is generally presumed, that presumption can be overcome if a state has consistently refused to join a practice or to accept it as law. According to the doctrine's recognized definition, a nation that regularly and blatantly opposes an emerging custom will, if the new rule eventually forms, not be bound by the rule in its relation with other states. Consistent with the rules applicable to the formation of custom, the option to object is open to all nations. This can be applied in the asylum case, where the main dispute was whether Peru was bound by an alleged local custom which had granted a diplomatic asylum that would force Peru to allow for safe passage of the general to Colombia. To prove customary rule existence, Colombia has presented many such cases in which diplomatic asylum was respected. However, the court had transparently stated that Peru can never be bound to this custom, even if the case that Colombia had successfully proven its existence, since Peru had never had attitudes in conformity to it and had, on the contrary, persistently objected to such customs during its formation. The ICJ expressed that it needs to be proven that customs are established in a manner that it had compulsory become binding on the concerned parties. This case abides by the principle that custom is created and will become binding only if it will be in accordance with regular, constant, and uniform use by the states. New nations, however, is generally held cannot choose between the various rules of customary international law. They are bound by all of the accepted customary rules at the point of independence. It does not matter that such newly independent states were unable to object to rules of customary international law as they were being formed. However, it is important to note that there are certain rules of customary international law which are considered so vital that they cannot be contracted out by individual states. Peremptory rules are known as jus cogens norms. The compliance with these rules is obligatory for such essential purposes as the maintenance of peace, security, and the order of the world, and also for the respect of human rights. The Vienna Convention on the Law of Treaties defines jus cogens as a peremptory norm of general international law, which is a norm accepted and recognized by the international community of states as a whole as a norm which no derogation is allowed. This definition, that no source of international law is superior to jus cogens, running parallel to jus cogens norms, are what are called obligations erga omnes. Obligations erga omnes are obligations considered so vital and important within the international system that any state, whether directly affected or not, may sue another state in order to compel the obligation to be met, such as prohibition of racial discrimination, slavery, aggression, and genocide. In this way, obligations erga omnes can be seen as a determinant in questions concerning jurisdiction and standing in international law. There are some disagreements on how widespread and uniform state practice must be. Practice is supposed to be general in the sense that all or almost all of the nations of the world engage in it. But it's practically impossible to determine whether all of these nations of the world engage in a particular practice. It is thus unclear when and to what degree the state practice requirement must be satisfied. Additionally, other scholars have dismissed customary international law as increasingly irrelevant, partly because treaties have codified many legal rules that were traditionally regulated by custom, in part because treaties offer putative advantages over custom, such as precision in language, and in part because custom is plagued by doctrinal confusion. However, customary international law continues to be one of the significant sources of international law. Customary international law is more widespread in its binding powers in comparison to treaties. It is said to be an essential addition to the generality of international law in terms of its binding power. Therefore, in certain circumstances, the customary international law fills the gap, obligating the states not wanting to join treaties. The moral value of customary international law flows from its ability to govern all with no distinction. Hence, it can be said that customary international law is a flexible branch of international law. With the increasing number of independent countries, it is now harder to follow an unanimous pattern of customary international law. Codification and express ratification is needed for every single norm that has to be binding these days. However, this does not mean that customary norms are getting obsolete, as the ambit of laws that exist are wide and the codified laws are binding upon only those who had expressed consent to follow them. But the customary laws which are based on humanitarian grounds are simply binding upon everyone. For example, customary international law usually deals with natural laws and humanitarian laws, so they do not need to be ratified in order to be binding, as these laws do not require any states to expressly do something through their resources, but are required to not make any contradictory laws of customary international law. Most of the corpus of international human rights law had taken the form of treaties, such as the International Covenant on Civil and Political Rights. However, the Vienna Convention affirms in Article 38 that a non-party to a treaty that contains a particular norm could also be bound by a similar norm, which is to be found in customary international law. For example, customary international humanitarian law is a part of customary law, and it simply refers to uncodified public international law norms that governs the conduct as well as legality of armed conflicts. There are multiple treaties on international humanitarian law, such as Geneva Conventions, that have been universally ratified and binding upon all. But not all such treaties have been ratified by every nation state, and such laws will be binding only upon the member states that have chosen to follow such law. Customary international humanitarian laws thus bridges this gap, and even those states which have not ratified any humanitarian treaty are significantly bound to follow customs during an event or armed conflict. Moreover, the distinctive features of custom, where it is unwritten, benefit from the rules as such without the need to make specific demands and concessions. Unwritten practice suffices to bring about an agreement about general rules that lack detailed provisions. Thus, the unwritten character of custom helps to secure states' agreement to a legal norm articulated at a high level of generality by deferring potential disputes over specific interpretations or application. All states benefit custom often arises from areas of interstate behavior were previously unregulated by any international rules, and it consists of legal norms that are articulated at a high level of generality. Lastly, technological and ideological advances have led to an escalating need for international regulation over new areas, objects, practices, and ideas, and the need for regulation is spurring the creation of new customary international law. In the absence of directly relevant treaty law and in the need of reliable guiding principles, states are developing practices standardizing their rights and duties in these new spheres. In most cases, states will justify their actions as lawful under the adaptive interpretations of broadly related treaty texts. However, existing treaty regimes may not address the full range of situations. Therefore, we can say that in some areas of customary rules may provide greater precision since they evolve in response to concrete situations and cases are often articulated in the written decisions of international courts and tribunals. In conclusion, customary international law has played an important role in establishing diplomatic relations between the states. The customary international law has no doubt positioned down due to developments in several alternative sources. However, customary international law have a wider scope of applicability and are binding upon everyone. They are the basis of every international law that is prevalent today, and every new norm must still abide by such customs. Hence, there is still a law vacuum in many areas of international law, and the need for legal rules is a necessity where customary law is able to provide some sources of law in such cases. That's all from me. Thank you.